Thank you very much, Camille. That was a really interesting aspect of the litigation funding industry as well, and hopefully a growing area for funding as well, both here in Europe and in the US. So I would like to welcome our first panel today. Thank you for coming. I would like to focus this first discussion on the state of the market in the UK and Europe, and I'd like the panelists to introduce themselves.
Matthew Lowe, Director from Exton Advisors.
Rachael Mulheron, I'm Professor of Law and Civil Justice at Queen Mary, University of London.
I'm Susan Dunn, founder of Harbour Litigation Funding.
Christiane, Deniger, Director at Burford Capital.
Do we hear the mics? Okay.
No.
No.
It should be on. No. That sounds quite noisy.
Shall we do this again? Sorry. Just to test the sound.
Matt Lowe, Director, Exton Advisors.
Rachael Mulheron, I'm Professor of Tort Law and Civil Justice at Queen Mary, University of London.
Susan Dunn, founder of Harbour Litigation Funding.
Christiane, Deniger, Director at Burford Capital.
Sorry, is this better? Because I still can't hear very well.
Yes.
It's better. Okay, perfect. Just me then. So for our first topic, I wanted to look at the trends in the litigation funding market, and also given the current macroeconomic environment, where are we with the litigation funding industry and current structures? Susan, maybe we'll start with you as the chair of the ALF as well.
Thank you, and lovely to see everybody. It's quite staggering to see standing room only at a litigation funding conference. On the 1st of March, I marked 22 years in litigation funding, and there would have been just me and a woman called Madeline, who was my assistant. So it's amazing to see how this has all grown over the years. I think the trends in the past, if we're looking back over the past year, one cannot ignore PACCAR. PACCAR has had its own impact, which is we've been working earnestly to resolve, and I think we're very much nearly getting there, although it's never over till it's over. And that has brought into focus then the way in which funders charge, because there's been this switch that funders made to multiples in order to overcome what was found in the PACCAR decision. That, of course, has its own knock-on effects, and it's important that people are then focusing on what the pricing is. So I suppose it's brought pricing into stark relief. The second thing that I think we've seen is that I think there's been a real reduction in the availability of funding for the very large cases. And people say to me, what does very large mean to you? And we measure that in budget terms. But I think that it's a challenge to find funding sources for claims with budgets of over £15 million in a way that it wasn't a year ago. That money was still much more freely available. And that in part comes about because of the macro environment that we're in, is that everybody finds raising money at the moment difficult. That's not just litigation funders, that is everybody in the market in a world of high interest rates. So the availability of funding is probably more limited than it was a year ago. This then conversely has an impact on pricing upwards, and I think that's the major impacts that we've seen are the combination of those two effects on the focus on pricing.
Thank you. And Matthew, you obviously have a great overview of different transactions in the market, and also working with both claimants and funders and different parties for the transactions. What trends are you seeing in the area?
Thanks. Yeah, so I think a couple of general observations. One, there still seems to be a lot of energy and focus, I'd say, in the group/collective space. We are seeing the funding appetite start to pick up a little bit after all the turbulence that was caused by PACCAR. That being said, pretty much since I started in funding, funders have been always keen and always crying out really for what they would call, or what I would call, vanilla commercial litigation and arbitration, allegedly, more straightforward cases, and for whatever reason they just seem to be a little bit harder to come by. But I think that the main reason for that is that relative to the group stroke collective actions that I mentioned, they're not necessarily exposed to the same budgetary or concentration or duration risks, and that there are often sort of stronger settlement dynamics that can be attractive for funders who are, they're concerned to preserve their IRR over a period of time. And I think secondly, in terms of the wider economic environment that Susan touched on, there is this common notion that is discussed around third-party funding as being a counter-cyclical or uncorrelated asset class. And I think there is some truth to that notion, but as well there are limits to that concept. And I think we're seeing now that funding isn't immune to the wider economic environment. And as interest rates have gone up, there's been in general a challenge to the relative value of funding as an asset class when compared to other, I suppose, more mainstream asset classes. As investor target returns go up, that has a knock-on effect, I suppose, and placing upward pressure on pricing. And I think, as well, connected to that, some funders have found it more challenging than they would have done 5 years ago, let's say, to raise capital because of the increased cost of financing. And that can place them at a competitive disadvantage potentially to other more well-capitalised funders.
Thank you. And Christiane, what are you seeing both challenges and opportunities in the market?
Well, based on kind of what Susan and Matthew just said, the difficulty in raising capital for some funders has actually been really beneficial to us because we have various lines of capital, including our balance sheet, which we can dip into. And so our pricing hasn't been as affected as some of the smaller funders. But what we're really seeing, and I do think this is a result of the increase in interest rates around the world, are listed companies coming to us with a bucket of maybe $200 or $300 million worth of litigation and arbitration globally that they are seeking funding for. And this may be with 7 or 8 different law firms. And what's so great about this is we wouldn't have seen this 5 or 6 years ago because listed companies thought they didn't need the capital. And whilst they still don't need the capital today, they are ready and willing not to spend their own money if they can take ours or another funder's.
Thank you. Rachael, do you want to share your view on the market as well?
Yes, quite apart from and in addition to what my colleagues have said, I think one of the trends lately has been the increased scrutiny on third-party funding. And I mention in that respect 2 things. First of all, when Alex Chalk made the announcement on the 4th of March that the government was minded to reverse PACCAR, there was also a paragraph at the end of that announcement which was quite significant, I think, and which was that the government has in mind to do a review of third-party funding which may include a greater regulation of that space. And the details will be provided in due course, he said, and I thought that paragraph was quite significant. And the second point is that the Legal Services Board is currently doing a study on third-party funding, and I'm doing that for them, and some of you very kindly have provided information to me already. As a little call-out, if any of you do have a particular point that you feel strongly about with respect to third-party funding, please get in touch. This is not the last word on third-party funding, but there is an increased scrutiny on it now, so if one does want to bring matters to the attention of these parties, then please take the opportunity, very much anonymously worded, no names, but it would be interesting to hear from you. But I think that is a trend in the last sort of 6 months, and I don't think that's going to go away.
Thank you. And maybe let's sort of look at it in a bit more detail. Obviously, PACCAR decision and some other follow-up decisions have shaped our industry and the structures used for funding. So maybe, Susan, to start with you, if you can give us your view in more detail on the PACCAR and its impact on the industry, as well as maybe share as a chair of ALF on comments or progress of the various legislative initiatives that are taking place now.
Yeah, so I think about 6 or 9 months ago somebody said to me, would you please write a chapter for my book about PACCAR? And I said, no, I won't, because my plan is this is a footnote in history, not a chapter. So we've had a long and winding road in relation to PACCAR since the judgment on the 26th of July last year, during which there's been an enormous amount of hard work by people both at ALF and at ILFA, campaigning with people in the Commons, in the Lords, the various civil servants in various government departments, and lots of sort of one step forward, two steps back. But to cut through all of that, on the 4th of March, Alex Chalk announced that there would be a piece of legislation just to deal with PACCAR. And as somebody at the MOJ said to us last Thursday, you don't know how unusual that is, so your nagging has worked. Now, what will happen next is that there will be this piece of legislation which will essentially put things back to where we were pre-PACCAR. That is going to go through a slightly expedited process because it's going to start in the Lords, then go to the Commons, and then come back and finish in the Lords. And all other things being equal, that should happen by the summer, that we'll know where we are by the summer recess, which is about the 23rd of July. But it has got to go through various readings before that date. And of course there is always a possibility that somebody pipes up and says, well, let's have a look at this. But it is tremendous, I mean absolutely tremendous, that the government has recognised just how detrimental the PACCAR decision has been, and it's causing an enormous waste of court time by defendants trying to use it to try and defeat the defunding which is underpinning the claims being brought against them. So I remain cautiously optimistic that we will have something in place in realistic terms by summer, even if it maybe doesn't get royal assent until after the summer recess. I was not happy when people started talking about a May general election, because that would have got in the way. But I think as long as we stick with a November date, then we should be good to get that done. And as I say, when people say to you, what did you do with this great works that you did? Well, nothing much really. We just put things back to where they were. But that will be a very important place for us all to be.
Thank you. Yes, and I think it is tremendous that the government does recognise that there is this issue to be dealt with, and all the work that is being put in place. Matthew, and sort of again from your wider perspective of deals being negotiated in the market, what sort of changes you've seen to the funding structures, to the structure of the return for the participants, and maybe any data you can share as well?
Absolutely, yeah. I mean, as Susan mentioned, the sort of the simplest solution that funders have been taking is a move more towards multiples rather than percentages. Some of them have been involving IRR functionality in their LFAs as well. We're seeing more multiples of committed rather than deployed capital as well. That's another option that funders have been using. But all of this does have has an inevitable impact on the alignment that is created. Obviously, the percentage, arguably, it does create quite good alignment between the parties relative to a multiple, which can have, it has an impact on the settlement dynamics. But I think, when the PACCAR judgment came out, we did look at our own internal data to try and sort of understand the extent of the impact that this would have. And our sense from our data was that the percentage actually was only defeating the multiple, if I can put it that way, in less than 10% of the situations analysed. And I think that, it obviously indicates that the multiple is in fact less favourable for the client in a lot of situations, and I think that reflects, I suppose, the underlying reality that we probably all don't like but appreciate, that litigation does tend to cost more and recover less than was anticipated at the start. That's not necessarily the same as saying that it has no impact from the funder's perspective, because of course the relatively rare situations where the percentage is applicable, they could be very important nevertheless if they are the outliers within a funder's portfolio that are especially profitable. I think another impact is that we've started to see, and I think pending the legislative fix, we will continue to see that lawyers, that there's more of an opportunity now potentially for lawyers to act on DBAs with their funding arrangements in the background. Now that obviously at the moment that doesn't work for opt-outs in the cap, but and indeed not all law firms are comfortable acting on that basis, but that option obviously remains on the table otherwise.
Thank you. Yes, we're definitely seeing a number of options, as you mentioned, change to multiples, having a fallback option, having some sort of notice mechanism which can then deviate between the two options, a multiple or percentages or a hybrid DBA, so this is very interesting to see how market develops. And I also found it's interesting when an event triggers us testing, in a way, our funding agreement, sort of in a bit of like it happened when Lehman fell and we all started looking at the boilerplate in the LMA documents, right? So here it was a really good exercise going to those sort of provisions and checking how they work in practice and whether they withstand the test. And in our experience, negotiations actually went really well on completely different transactions, and the parties were able to overcome this hurdle and sort of put in place amended documents. So that was really good, I think, exercise for the market to go through as well. Christiane, what sort of how Burford adopted to this challenge as well?
Most of the cases that I work with, I'm an arbitration specialist, are not London-seated cases. So this has not been something that has affected US-seated American funding agreements, and nor should it affect anything, and that's really all I'm going to say about PACCAR.
And that's true. That's actually, yes, another way where we looked with our clients on whether we can change governing law of the documents to address the issue. And Rachael, maybe it was really interesting in the introduction what you mentioned on the initiatives. Maybe if you can give us a little bit more detail on the process.
Yes, I think there's been an unfortunate conflation between PACCAR and regulation. They are two entirely different things. The reason PACCAR became an issue is because of the piecemeal drafting of legislation that was way back from the 2006 Compensation Act, and how it then interrelated with the Courts and Legal Services Act, Section 58AA, which of course is imprinted on all of our brains, the definition of a DBA. We'll never forget it, but that's really what the source of that was. It was the uncomfortable interplay between those legislative provisions which led to PACCAR. That's got absolutely nothing to do with the fact that third-party funding is self-regulated in this jurisdiction, and there has been, I think, an unfortunate mix of those two. But in relation to the reversal which Alex Chalk has mentioned is the government's intention, I think that well, we have to see, don't we, as to what the terminology will be, but it's certainly the gentlest way of reversing PACCAR would be to accept the ratio of Lord Sales and the majority in the Supreme Court, which is that third-party funders do offer claims management services as they were defined in Section 4.2b of the Compensation Act 2006. But make sure that under Section 58AA, it is only those who offer litigation services and advocacy services who can enter into a DBA, that is, drop out claims management services from that definition. And that then would mean that funders cannot enter into a DBA because they don't offer litigation services or advocacy services. Now, whether that is the solution that comes forward, we will have to wait and see, but that would be the gentlest way of dealing with the PACCAR point, but certainly it's a separate point from regulation, and that's, in a way, those two matters were conflated in that announcement too on the 4th of March, but they are different issues.
Yeah. And how do you see sort of the general wider regulatory landscape for the industry?
Yes, as I said in my first comment, I think it's on the horizon. And given just the quantum which Camille mentioned in her keynote speech, her excellent keynote speech, this is a very active area now, and I think everyone would say that there's a need for greater oversight. In my view, there's two strands to that. There's the prudential strand and there's the conduct strand. And so the prudential strand is very much the public confidence in the fact that there is capital adequacy that is safe and that the funders will be good for the money, so to speak. I think that's prudential. But the conduct aspect of it is very much the nuts and bolts of how funding works, and just things which are terribly important, such as should there be a cap on the success fee, or shouldn't there? If there is, what should be within the success fee cap, such as the expenses? Should any expenses be outside the cap? I mean, I know it sounds terribly dull, but it is terribly important. And I think, with the greatest respect, that sort of thing wasn't perhaps paid enough attention to in the DBA legislation back in 2012, 2013. But having said that, I think one of the reasons that the code has been so successful, and let's face it, it's getting on for 15 years old now, that code, was because funders were around the table when it was drafted. And so I think that's incredibly important to the exercise going forward. If there is to be the conduct regulation, I think there has to be the involvement of funders so that it works and that it isn't a chilling effect upon the funding. So prudential and conduct, I think, might be the two ways of looking at it going forward.
Can I just pick up on that, because I feel quite strongly about regulation. We get this quite a lot. People say the word regulation as if it's some kind of panacea for what, I'm not quite sure. And my response is always, look, I suspect we're already doing the things you want us to do. Could you explain to me what it is you think this regulation is going to do? And Rachael quite rightly identifies prudential and conduct. I think that most of the things that anybody might contemplate, if you take an extension of the Code of Conduct, which Alpha's operated under since 2011, are things which are uncontroversial to the majority of us. However, I am very, very clear that caps is a huge mistake, that there should not be caps put into any form of regulation, because what we've seen, there's an example in Germany where they've sought to cap returns on a particular type of case at 10%. Guess what's happened? None of those cases are being funded because the funders have just said, well, that's not economic. And I think one of the things that we're still very little understood, and it's our job to make ourselves understood, is quite how much crap we put up with from defendants, some errant claimants, etc. I was told it's not Chatham House, and Desiree's going to look at me and go, don't say crap. I don't think people fully understand all the twists and turns in the road that we have to the journey to recovering monies, the disappointment that comes in the reduced claim values, the budgets that overrun, the way in which people try to renegotiate our terms as the money is coming in. All of these things that we who have no control over the way which the litigation is run are subject to, and I think people still have this misplaced notion that we make out like bandits on everything that we do, and we don't, and the capping of fees would have a very detrimental effect.
I think that's exactly the problem, that the chilling effect of wrong regulation is what is to be avoided. I mean, public confidence has to be maintained in funding and capital adequacy and so on, but it's the mechanics of how it works which is so important. And I go back to the DBA legislation. I know Nick Bacon is going to speak to you in the second panel, but Nick and I have pored over those DBA regulations and have sought to make reform suggestions, and it is very much the particulars that matter, and if those particulars don't work and don't fit together properly, the whole funding regime won't work. So I think that's why funders and external parties have to be around the table if we go forward as to what will enable funding to work in this jurisdiction.
But also I think there is so much focus on litigation funding because it's a new industry, as it is on any new industry, regulatory focus. But if we look at real estate finance or other leverage finance, there are no caps there on the return on interest rate that the funders, the lenders are charging. So the market regulates itself, and as Susan said, if the terms are not commercial, then there'd be no funding, no lending in place. Yeah. Matthew, Christian, do you want to add anything?
Yeah, I mean, absolutely. I think that there's nothing necessarily to be afraid of about regulation in principle, but the devil is obviously in the detail. Though it was an interesting survey last year from the London Solicitors Litigation Association that highlighted 80% of litigators in London believe that it is time for the third-party funding sector to be regulated. I suppose ultimately it's a matter of balancing, on the one hand, the protection of claimants that may be in a less strong bargaining position against the risk of damaging access to justice that comes through third-party funding. But there is sort of one discrete point that I think is quite interesting around the recoverability of funding fees that may or may not be part of this discussion. It's obviously an important issue, and following the SR and 10K decisions in England, we have this, what I think is rather curious divergence of the position between litigation or English litigation, where these costs are no longer recoverable after, and I include things like the ATE, Premier and CFA success fees following the Jackson reforms. But you contrast that with English-seated arbitrations where they have been held to be recoverable. And Obviously, just sort of stepping back, it goes right to the heart of our system, civil justice system, that the successful claimant should be put back in the position that it was in had whatever the wrongful conduct was never occurred. And without the ability in the right cases, and I'm not saying every case would be the right case, to recover funding fees or CFA success fees, AT premia, that objective, it doesn't get achieved. And it's interesting, I think, because there's no obvious principled reason for there to be any difference of the position between litigation and arbitration. So, to my mind, this is one of the important sort of levers, push and pull policy considerations that we have around access to justice. And in general, the English courts take there is a wide approach to how a wide discretion as to how costs will be dealt with, and I can certainly see the argument that there would be benefits to, in the right cases, an ability for the courts to exercise their discretion, in relation to the recovery of funding fees as well.
That's interesting. Thank you.
Just 2 quick points on that. In relation to regulation, I don't really think we need any more than what we already have. But to the extent it will be imposed on us, we need to mirror what we did in Hong Kong and Singapore in around 2014 to 2016 when we were negotiating, and they involved all of the main funders at the time in negotiating and setting up the various rules on disclosure, on funding more broadly. And all that really resulted in was having to disclose our involvement, not the SPV 5 steps down the line, the main funder, as soon as possible once a funding agreement has been entered into. And that is fine. We at Burford and at most of the ALF funders and ILFA funders have no problem with disclosure. We stand behind the cases we invest in, and that's extremely important. Now, as for disclosing our existence, that creates an unfortunate reaction by most respondents. This is particularly in arbitration, but it can happen anywhere. They will immediately apply for security for costs. Then they'll do a separate application for disclosure of the funding agreement. And sometimes, at least in arbitration, they'll seek to have one of the arbitrators removed because he or she may have worked on a funded case at one point in their career. What this has is it creates an excess of cost that now the claimant or funded party must bear. And it can be anywhere from £1 million to maybe £4 million. Now, when it comes to recoverability, these extra costs that were put upon the claimant by the respondent as a delay tactic, more often than not, because very rarely do any of these applications succeed, I think very much should be recoverable. I may be in the minority there, I doubt it, but I think this is something we need to consider when spurious applications are made to create delay and discomfort. That should be recoverable.
Thank you, and interesting point on the disclosure, and I think we'll touch upon it in a later panels as well on the developments in this area. And just sort of go back to the trends that we mentioned at the beginning when we were talking about the sort of more limited availability of funding for larger transactions on one side, but also development of the market, and we have seen really large investments in the litigation funding industry in Europe. So I just wanted to sort of touch upon the co-funding and secondary opportunities in the market and what we're seeing there.
Yeah, well, I'll just kick off on the co-funding, and I'm sure you have plenty to say about the secondary market because Burford's particularly experienced in this area. What we have seen in the course of our current fund is a lot more appetite by people who are both in our main fund as investors, but also come alongside and outside those funds, wanting to take part in particular types of claims. Now that can be anything from facilities for law firms, which I know you've got a session on later, which has been a significant growth area, but it can also be that they just happen to like particular types of cases, particular jurisdictions, and so therefore say, can we carve out those types of cases to co-invest with? That's great for adding additional funding to what it is we're doing. It also adds a layer of admin, for want of a better description, because there's a whole different way that they might want to interact, whether they want to be on the investment committee for the purposes of those decisions, how they're kept informed about things, who these people are. Because these people might well have no background in litigation funding, but have identified it as an asset class they want to be involved in. So there's a lot of education that we need to do to get them comfortable with what they're doing, and not just get them comfortable, but it's about then understanding when the inevitable rocks in the road happen, as to understand what they really mean, because it can just seem like, oh, this is bad news, but what we're used to knowing is, well, bad news happens in everything that we do, but it doesn't mean the end of the world. So there's a lot more educating that goes into that, but I know Christiane will have a lot to say about the secondary side, because they've been very active in that regard.
Yeah, and just on the co-funding point as well, it's there's a lot of smaller funders who want to invest in the bigger things, and they simply can't, for budgetary reasons, invest the 10 to 20 million sterling range, and they will come to the likes of Harbour or Burford and say, any chance for a co-fund? And that can be difficult, because if we're going to co-fund with another funder, we need to make sure they're around for the long haul, and that can be something that's harder to be certain of in early days. And there's also the complication of, well, and this seems a bit silly, but whose transactional documents are we going to use? Who is in charge of the budget? And as Susan said, who's on the committee? Who's making, to the extent we can, decisions here? Now, in relation to the secondaries market, we operate extremely heavily there, and that also comes in two different ways. We have other funders who want us to invest in their already funded portfolios, and that is an interesting but sometimes challenging situation, because not everyone does their diligence in the same way or are willing to share as much information as we require internally for our investment committee. And sometimes we see, now that Susan said the word crap, I can use it too. We see the crap that, 10 years after investment, we're like, wow, that was a choice. But we do or don't move forward with that. But what is also quite interesting is the amount of asset managers and PE funds who are now looking to invest in awards that we're seeking to enforce, or that want to sell us portions of their awards so that they can get out and close down the fund that has been around for 12 years and the limited partners want out. So it's a really active market.
Thank you. What we are seeing a lot on our side as well, as you mentioned, multi-strategy funds, maybe from US or Europe, look into this space. Real estate funds, distressed debt funds, look into this space with a view to enter it. And again, there is a lot of, as Susan said, a lot of education that needs to be done there to understand, the risks and involvement in the process. But on the other side, again, I look back at maybe because my background is leverage finance, at the multi-committees of lenders on big leverage transactions, and so we do sort of have a precedent there, maybe with more equal lenders with a more equal experience in the industry, organizing together and doing really big multi-billion lending transactions. So there is a precedent there. Matthew,
Yeah, I think certainly from our position in the market and in the current economic environment, we are seeing some increased demand amongst funders in the broadest sense for secondary action and risk-sharing solutions generally, whether that be co-funding or syndication. But I would echo the comments from the rest of the panel that our experience is that there can be challenges around that. Pricing in particular, there's often a fairly big sort of bid-ask spread, if I could put it that way, and there can be difficulties in terms of how investments are going to be managed moving forward between the collaborating funders, and there's no doubt that those are hurdles, albeit they're hurdles that can and they obviously have been overcome where the right partners and the right cases are involved. Certainly where a particular funder can manage the large ticket itself, while there may be a theoretical interest in co-funding. In our experience, they often prefer to do so because it's so much simpler for them to do that.
And also, I guess co-funding or secondary opportunity is really great for the duration risk as well, because different time funds come into different timing in the market, and sort of that helps balance this. And just to touch upon the law firm funding, we have a separate panel on this, but this is such a big trend that we are seeing in the industry. Again, different funders looking to either partner with or invest or fund law firms of all sort of types and structures. So, Christiane, what is sort of Burford take in this area? I know you've both you and Susan were very active in this space.
Yeah, so we've been doing this in the States for years. We've been, investing upwards of $100 million in a variety of different law firms, particularly in startups, and I'm so happy that we're starting to see interest in doing that here. In my experience in the UK, it has been smaller numbers, and it's normally people wanting to set up a much smaller new boutique from scratch. But I'm really optimistic that this will be a great way to also increase diversity in law firms. If we can provide some form of finance to a diverse group of panels, new partners in law firms, we might create a really interesting new face in law.
Mm-hmm. And how sort of do you assess the insolvency risk, which I guess is the biggest with the law firm?
Do you want to take that?
Well, yeah, again, I must keep Desiree in the corner of my eye. It is extraordinary what we see, and how often we go in and look at things, and I'm very basic in how I assess these things, but we often end up playing back what our analysis tells us to the law firm. They go, wow, we had no idea that that's how we're doing. And so I think once that exercise can be super helpful to understand for them lines of business they're doing they shouldn't be doing anymore, things that they could be focusing on better. There is a great tendency to underestimate the duration of how long it's going to take to repay these monies. And we want to be confident, not just that we're going to get our return on this investment, but that they can pay it and that they are left with a profitable outcome. Because if at the end of it they just feel like they've had to pay us because it took double the length of time, everybody's fed up, that's not in anybody's interest. So we are trying to make sure that people are content with what they're doing. And we've seen some examples with the high volume, low value stuff where enormous sums of money were put in based on not a lot of diligence. And Christiane's point about that earlier is like, wow, how did you make that decision based on one PowerPoint? That's quite extraordinary, but yeah.
Yes, no, exactly, and we'll have a more detailed panel on this later, but we are seeing as advisors still disconnect between what the funders need to see on commercial side, on the numbers, on the way the law firms operate, and this sort of what law firms on one side offers this due diligence information, and also expectations that law firms have from the funders. So it's very interesting, and we talked about this I think 3 years ago when we did the first conference, and when we still sort of work with both parties to bring the deal together.
I mean, in fairness, they're just not used to having to do it. So it is a whole new way of having to operate. They keep their own numbers for, look, we made this much money, we made this much profit. They're not used to that having to deconstruct how the firm works, the granularity of the profitability of cases. So we're quite sympathetic that it is a new thing for people.
Yeah, no, that's very interesting. And we, for example, at Rudnick have a CFO, and we look a lot in our financials. But just talking to law firms and trying to extract this information on records on how many cases were successful, what were the timings, cost overruns. Yeah, that's still a lot of work there. Matthew, I guess you're seeing that as well.
Yeah, I mean, I would sort of broaden it out slightly and say that there's a trend generally in the current climate for funders seeking, I suppose, greater diversity in their business models as they look for more and better ways to deploy capital outside of just the traditional single case financing. And I think we are seeing continued interest in law firm financing, which I would say forms part of that trend.
Thank you. And then just sort of a general question. So do we think that given all the macroeconomic situation, various challenges in the industry, London will remain the hub for the litigation funding in Europe, going forward? Or what maybe needs to be in place for it to remain main centre for funding? I'll speak this up.
Well, I mean, just to kick off, I think sorting out PACCAR will be tremendously helpful. No investors like uncertainty. They know they have uncertainty, but they want to remove as many layers of uncertainty as possible. And what has upset me about PACCAR is it has undermined what is a fabulous jurisdiction. It is still I know I'm English, but it's still my favourite jurisdiction in which we operate because of the high degree of certainty, albeit with some outliers in that sort of thing. And I know that we are post-pandemic now, but this jurisdiction excelled head and shoulders above every other jurisdiction in how the judges and the courts were able to perform and execute cases through that time. And I was so pleased that we were able to demonstrate that when we were looking at other countries around the world who simply weren't up to it. So that was amazing. So I think if we can make PACCAR history and then just carry on looking forward, I think this jurisdiction has every reason to believe that it should remain the leading jurisdiction, I have to be a bit careful, in the world.
I tend to agree with Susan, but one thing we're seeing is lawyers telling their clients who want to bring an arbitration to delay until this is resolved, or to try and find another seat, and that's upsetting. So we need to get this sorted if we want. I'm an English qualified lawyer only, so I do think this is a great jurisdiction to work in, but I understand the reluctance right now.
Yeah, same with governing law, right? Sort of starting looking at the contractual law for the transactions. Rachael, Matthew?
I agree. I think certainty is very important, but there needs to be the right balance between access to justice and that chilling effect. So I think going forward we have to make sure we get that right. And UK Legal put out a document last year which it said that the value of the English courts is that they can offer, particularly overseas litigants, certainty and high quality judicial appointments and so on. And the certainty has been so disrupted in this last 6 months. It's been very damaging, I think, to many. But just to finish off in terms of what would we need, I think we need to get the DBA regime worked out too. I know we're just talking about funding, but when you've got a hybrid DBA, when you've got the law firm acting on a DBA with the client, and then you've got the firm with an LFA with the funder, I mean, it's impossible not to, you can't ignore the DBA legislation and go back to the fact that it isn't right yet. It has to be fixed, and it's only when it is fixed that the certainty that funders need will be there. I don't think we can ignore the DBA regime. It does need fixing.
Yeah, I mean, I would just echo the comments of the panel. Uncertainty is obviously bad for everyone in the chain, apart from the defendants and their lawyers. I think that in England we do have a strong, obviously there's an attraction there in the sense of there being such a strong legal profession, judiciary and legal system generally. But we need not to be complacent in the way that environment is managed, and solving issues like PACCAR and the DBA regulations is obviously an important part of ensuring that we don't sort of slip behind the other jurisdictions.
Thank you. And just before we turn to questions from audience, one point that did come up in our pre-panel call that we didn't mention here were competition cases. And obviously this is, we'll have a separate panel on this, but obviously this is sort of an area which has a lot of uncertainty as well. I just wanted to sort of ask the funders, are you delaying your decisions to look in those cases? Is there any limitation of quota with respect to competition cases, or what sort of, and also what do you think will be the trend in the next 12 to 18 months to the extent we can comment on this?
We're continuing to look at CAT cases. To the extent we think they are good cases, we will continue to fund them or seek to fund them.
And you're not sort of making difference, so it's a CAT. Yeah.
They are very expensive. They are way more expensive than other pieces of litigation that we fund. And it boils down to we have choices. We have to make choices every single day about, is this the best use of the money that we're asked to look after? And I mean, our case is right in trial at the moment, the BT claim. So hopefully that might provide a little more insight into how the system works and that sort of thing. But it's still very, very young in terms of precedent and understanding of how these things will be valued. And I mean, there was a helpful decision, I think, yesterday, which said that the funder can take from not the unclaimed part of the damages, but from the damages. All of that is helpful, but it's striking, isn't it, that it's only yesterday that that was clarified. So if you go into other parts of the system, there is much greater precedent, certainty, understanding, and we used to be called the pioneers of litigation funding, and then we sort of went, do you know what, being first isn't always the place you want to be. Sometimes it's better to let others go first and then go, okay, now we know what's going on here. So I think there's still a lot to be unpicked about what's going on in there, but it would be great. I mean, it's such a valuable forum, doing really good things to hold corporates to account. So I desperately want to see it succeeding, and for there to be this increased momentum for the resolution of what is broadly bad behaviour. Let's not forget, almost every case that goes in there, those defendants are admitted cartellists or other fines that they have faced. So it's a really important forum.
Yes, absolutely, and I think it's helpful to have decisions like the one we had yesterday in the right directions. Well, I thought it was a very helpful overview from the panelists over the market. I don't know if there are any questions from the audience. Well, thank you very much, and please, in thanking the panel.